Welcome to part 3 of chapter 7, Torts in the Legal and Ethical Environment of Business by Terrence Lau and Lisa Johnson. This is Dr. J. Kent Gregory, and we will wrap up our discussion of torts. Let's move on to torts. And the last type of tort that we'll be talking about, or among the last, is mass tort. So a mass tort is a civil tort involving numerous plaintiffs against one or a few defendants. And keep in mind the doctrine of joint and several liability. So this is the doctrine where the plaintiff may pursue a claim against any party liable for the claim as if they were jointly liable. And then the defendants then sort it out. So the book gave a great example, which was the vitamin supplement example. So let's say you were taking a vitamin supplement and you had been taking it over a number of years and you had bought it from several different companies over those years. You then find out that you've gotten sick because of the supplement, and simultaneously the United States government has, let it be known that they have found that the supplement does cause people to be sick, cause certain things to happen. Well, since you were taking it over such a long period of time, and you do have injuries, as tort law would describe them or define them. You have injuries, but you can't really identify exactly whose supplement, uh, even though it was the same supplement, but which supplement caused the damages or caused the injuries. And it may have been all of them. So what you do is you sue one of them, and they're all liable for it. So there are two types of damages, or two types of award damages in tort law: compensatory, which is compensation for the actual injuries, and punitive. This is money awarded to the plaintiff when the defendant acts wantonly to punish the defendant and to defer future wrongdoing. So we talked about that a little bit earlier. So here are some types of damages. This is a great uh, chart that's in your book. So compensatory to the victim. So any foreseeable damages, these damages can include property damage, loss of wages, and pain and suffering. Compensatory to additional victims. In wrongful death or wrongful birth life cases, any foreseeable damages, including loss of consortium. So let's say wrongful death of a husband, the wife could sue for or claim compensation for lack of consortium. She no longer has her husband around. Nominal damage, nominal, so no actual loss or injury sustained. So the monetary damages are primarily symbolic. Punitive, we talked about that, and interest and attorney's fees. So must be in the statute or contemplated in the contract. So you can sue for your attorney's fees, and you also can sue for interest on money that you may have lost. So some defenses to tort cases. So there's the affirmative defense. This is a response by the defendant that raises a justification or excuse for the defendant's conduct. And basic affirmative defenses are assumption of risk, a defense in which the plaintiff is barred from recovery because the plaintiff voluntarily and knowingly assumed known risks. So, for example, bungee jumping or uh, uh, parachuting, those are types of risks. Uh, Sorry, I'm gonna see if I can get this smiley. Uh-oh, they're a little scared there. So here we go. He's parachuting there. Anyway, open and obvious. This is the doctrine under which the landowner is protected from liability if an invitee is injured by an open and obvious danger or hazard. Uh, some other defenses: contributory negligence. This is where, in situations where the plaintiff contributed to his or her own injuries. Comparative negligence. This is a partial defense that reduces the plaintiff's recovery by the amount of the plaintiff's own negligence. And then there's the Good Samaritan law. It's state laws that shield those who aid the injured from negligence liability. So they're designed to remove hesitation by a bystander in an accident may have any hesitation that a bystander in an accident may have to provide first aid or other assistance. And strict liability torts require neither intent nor a breach in the standard of care. So it's liability without fault. So since it can have harsh consequences, it's limited to very few circumstances. Ultra hazardous activity. So an activity so inherently dangerous that those who undertake the activity and cause injuries are strictly liable. So the book talked about uh, um, companies that transport uh, sorry toxic waste. Uh, they would be strictly liable for something that happens, or nuclear waste. Uh, so the, those are activities in which the potential plaintiff is engaging in them and knows that what he or she or the company is doing is so dangerous that it may cause serious problems. Dram shop acts. So dram shop acts are strict state laws establishing strict liability for taverns, bars, and restaurants for serving alcohol to minors or to visibly intoxicated persons, who then cause death or injury to others. Uh, so strict liability torts exist because businesses that engage in covered activities profit from those activities. And a famous case took place in Louisville. It was a dram shop act, or under the Dram Shop Act, when an individual was drinking very heavily and was, intoxicated at a restaurant, and then proceeded to go to another restaurant. And in both places, he was served. And then he got in his car again, drove the wrong way down a highway. I think it was Interstate 265, crossed the median and struck a car and killed the two teenage riders. Well, one was a driver and one was a rider. And so the restaurants were sued and lost, although they did not admit liability, but they were sued and they lost. Strict product liability. So under strict product liability, manufacturers, distributors, and retailers are strictly liable for injuries caused by unreasonably dangerous products. And it's under this that there have been some test cases, or potential test cases, involving firearms, right? Um, so can firearms manufacturers be held liable for the use of their firearms to hurt other people? So that's rather interesting. Uh, and to demonstrate that a product is unreasonably dangerous, plaintiffs have to have two theories available. So A, the product was defective because of a flaw in the manufacturing process, or a product may be defective because of a design defect. So this is not necessarily the issue with these firearm cases, but it may, if these cases do go through and they win, then it may add a third theory available. So to wrap up liability, product liability cases arise from the defective design theory because courts have held that warning labels on products and accompanying literature are all part of a product's design. And defenses are assumption of risk, product misuse, and then the danger doctrine. So that wraps up Chapter 7. Thank you very much.